And I'm pleased to be able to stand and take a speaking opportunity in the progress of this bill. And it's important to look at where this bill came from and what it is trying to address, and to look at the Children, Young Persons and Their Families Act the way that it has been practiced through until now. Because what we ended up with by the time that the National Party came into government, and to be fair to them, in the time of the former Labor government, they realised that there needed to be some alterations to it. Some of those alterations we supported, some of them we didn't. But what had grown over a period of about 15 years since the implementation of the 1989 Act was a lack of confidence in the ability of the implementation of that Act to deal with younger offenders, especially younger prolific offenders. And the reason for that was that because there is a lag time between apprehension and then finally being dealt with, this is 12 and 13-year-olds and the youth court as it started out, but 12 and 13-year-olds particularly, by the time they appeared before the family court. And a young child brought before the family court, aged 12 and 13, on a charge for, not on a charge, but reported for prolific burglaries, for instance, took so long to go through the family court process and the the family group conference process and the resolution practice before he could, get in front of a judge and to have a resolution. There had been a numerous amount of further offending going on from there. And what you ended up with was the practitioners, the police, and the youth justice social workers losing faith in that system and not initiating those sort of orders. In other words, doing next to nothing with those young offenders. And we've had the quoting of the name Bailey Kuririki a number of times in the course of this debate, but funnily enough by people who were not in a position to be able to hear the evidence before the Select Committee. But the whole thing was that, yes, that serious offending on that occasion crystallised in the minds of not only the National Party but the Labor Party that we needed to do something. Because if Michael Choi didn't die, then Bailey Kuririki wouldn't have been charged with anything, because there was no precursor for him to be able to be brought before the court. And the action that was taken in response to the manslaughter conviction that he sustained would have happened under the law as it is now and as it was then. So we've got to be very careful that we don't set about muddying the waters here and trying to think that this is some move by the now government to do some dirty deal and to deal to young people aged 12 and 13. Because what's been implemented as a result of the Select Committee process is that now we have a system where the youth court judge acts as the gatekeeper as to where those 12 and 13-year-olds will be heard, either in the family court or the youth court. So the police initiate a charge against a 12 and 13-year-old. The first appearance is in the youth court. And the person who decides whether or not that 12 or 13-year-old goes back to the family court to be dealt with or continues within the youth court because they meet that criteria is the judge. What is wrong with that? Who is best and most appropriate to make that decision? The judges. And when we had Principal Youth Court Judge Andrew Beecroft before the Select Committee, what did he say? Those who do here present? No, what he said was, what you are doing is you are trying to lump far too many 12 and 13-year-olds straight into the youth court. This is at his initial appearance, and he said what you need to do here, Select Committee, is streamline the process so that the practitioners working within the youth court process and within the youth justice process are able to get those 12 and 13-year-olds dealt with much quicker, get them onto curfews, get them onto adjournment provisions like bail conditions so that they are under curfew, so that there are non-association clauses and there are prohibitions from knocking around certain neighbourhoods when the crimes they're committing are happening. He said streamline it. So what happened? Well, those bits were pulled, they were rewritten, and we've done pretty much what he said. We've streamlined that process so that 12 and 13-year-olds appear initially in front of the youth court. If they are prolific offenders, they can have adjournment conditions put on them, and they can be sent back to the family court, and that is where the vast majority will go. But for those offenders who, because their previous offending or previous admissions, after they've had legal advice, which was another condition that was put in after the Select Committee process and on advice of officials, for those particular offenders, they will carry on through the youth court. And by doing that, they will be able to access programs that they can't access at the moment in the youth court. Now, we were criticised by the Labour Party spokesperson for social services for not increasing the powers of the youth court to those that currently exist within the family court, and those of us who were privileged to be in the committee when we discussed this actually know that we had a look at doing that and were told that we couldn't do that because the scope of the bill wasn't wide enough to increase the powers of the youth court along those lines, and so that hasn't happened. It's true to recall that the Children, Young Persons and Their Families Bill that was put up by the Labour Party when they were in government extended the provisions of supervision with activity and supervision with residence, and so what we have done is to glue onto the back of that conditions that they are then released back into the community on. And there are a number of things that was put up in that initial bill that we were happy with and the National Party was happy to support, and that was one of them. Because those on the other side of the House who have had the privilege to appear in front of to attend those supervision with residence courses know that a huge chunk, if not the majority of those young people who are sitting in those places right now are doing back-to-back 3-month courses. Some of them are on their 4th, 5th and 6th 3-month period that they've been sitting in those courses, and it has gone nowhere for them. And every time they've been released, they've had to go out and create a whole new set of victims before they can come back and access this that we call the justice system, and it's rubbish. And so we're pleased to have received, at least within the Select Committee, the support of those Labour members to agree with that particular bit, and it was foolish to ever have in a piece of legislation that before you could order a child to go and attend community work, that they had to agree to it. How ridiculous was that? And so we're pleased to see that change happen as well. We've heard a lot of talk about military-style activity camps, and I can understand why. It's a bit of a touchstone for people who want to give the whole thing a smack around. Let's look at where that came from. Where the introduction of military-style activity camps came from is from an agreement which is also bipartisan and across the House of the way that limited service volunteer courses work, and that the military component of academy education courses work as well. And yes, the point can easily be made, and it's well made, that people who attend those courses do so voluntarily, as much as those who attend as part of an academy volunteer, and that this is usually their last chance at education. You go on this or you're gone. Now, so what we have tried to do with military-style activity camps is to take the best of LSV, the best of the military component of the academic programs, and then to allow these young people, force them, by order of the court, to attend these courses and then wrap services around them that actually address, for instance, issues within the family, that deal with drug and alcohol issues, that deal with literacy and numeracy issues, and deal with violence issues, and deal with the background. So my colleague over here from the Māori Party talking about whānau ora, it is exactly that. It is reaching back into families, which the current system does not and cannot do and is not empowered to do. It is hugely frustrating to see a piece of legislation that seeks to intervene in the lives of young people, the most vulnerable in our community, who desperately need intervention, to have it shafted and ridiculed by people who want to put those sort of labels upon it, knowing all the time, having sat through that Select Committee process, that is not what is intended, that is not how it's going to work. And I urge this House to look within themselves and have the courage to be able to support this piece of legislation, because it is worthy legislation.